Members, it's the appointed time. We have a quorum. I call to order the meeting of the panel on security. Agenda item number 1, information papers issued since the last meeting. The Secretariat did not issue any information paper. Agenda item number 2, items for discussion at the next meeting. The next regular meeting of the panel will be held at 2:30 p.m. on 2nd of June, Tuesday. The Security Bureau has proposed to discuss 2 items. 1, youth development work of the Security Bureau and its departments. That is the first item in the list of outstanding items for discussion. The second is drug situation in Hong Kong in 2025 and anti-drug efforts of the government. The second item in the list of outstanding items for discussion. Do members have any comments on the 2 items proposed to be discussed? If not, thank you. Let's move on to the next agenda item. The next agenda item is legislative proposal to amend the Fire Services Ordinance, Chapter 95, and other relevant pieces of legislation. I now invite representatives from the administration to come inside the conference room. This is a legislative proposal. All council members are invited to join the discussion of this item. Welcome, Mr. Tan Ping Kang and the team. In a bit, I will invite Mr. Tang to brief members on the paper provided by the administration. Members who wish to speak, please press the request to speak button. All right, Mr. Tang, if you're ready. Thank you, Chair. We attach great importance to fire safety standards and the lives and property of the public. In the wake of the number 5 alarm fire at Wangfu Court, the government established the task force on strengthening fire safety governance, chaired by myself, and immediately launched targeted measures and put in place medium to long-term initiatives that would include enforcement, technology applications, public education, training, and planning for operations, including a comprehensive review of the buildings undergoing major repairs. And we adopted a risk-based approach and conducted inspections for 1,500 odd high-risk buildings. We also have the ambassador scheme for building safety. We are actively taking forward relevant work. We have the vision to protect people's lives and property. On an institution level, we are proposing amendments to the Fire Services Ordinance, Chapter 95, and related subsidiary legislation so as to keep up with the times. There are 6 pillars of amendments. We want to have a clear, reasonable, and pragmatic legal framework to hold people accountable and to enhance fire safety standards. I will highlight some salient points. First of all, strengthening the regulatory regime for fire service installations. We propose to have, before shutting off fire services installations, there should be prior notice so that we can play a gatekeeping role beforehand. We also have offenses that prohibit the interference of fire services installations, and that there should be mandatory notification if certain fire services installations are out of order, so that the fire services department can know in advance fire hazards in buildings. We also propose to introduce the concept of responsible persons. Apart from owners or occupiers of premises, we will include property management personnel in the regime of responsible persons so that they are also held accountable along with incorporated owners so that they can enhance daily management and take preventive measures. Responsible persons have to check alarm bells every 6 months, and when fire services installations are shut down or out of order, there should be additional safety measures in place, as well as there should be annual inspection certificates displayed. These are now statutory requirements. We will ask for these knowing that these are already in the contractual agreements of property management companies. So this should not be a heavy burden on property management companies. We will also reform the registered fire service installation contractor registration and disciplinary regime. We propose to have renewal done every 5 years. We will also introduce, for example, continuous professional development requirements. We also propose to introduce a registered regime for fire service installation technicians. We also want to empower the disciplinary board so that they can hand out different forms of punishment rather than just relying on revocation of licenses. We also propose to enhance the disciplinary procedures. We will enhance penalties and criminal accountability. We propose to increase penalties for multiple offenses, including for false certificates. We will have a higher fine as well as a prison term of 3 years. We will also introduce management criminal accountability for those who are proved to have neglected or omitted certain responsibilities. They will be held legally accountable. We want to increase deterrence to protect people, and we believe most of the relevant personnel are already compliant at the moment. We will also introduce a fixed penalty regime and have streamlined abatement of fire hazards workflow. We have referred to existing legislation, similar offenses in nature and seriousness to make sure the penalties are deterrent and that there is consistency in penalties. We also propose to empower the Fire Services Department to remove fire hazards and recover the charges from relevant personnel to protect resident safety. The sixth pillar is about expanding Fire Services Department's enforcement powers and combating illicit fueling. We will provide enhanced powers for the Fire Service Department to enter premises. For example, we will also specifically target illicit refueling activities at the moment that have been quite prevalent. We will have more harsher penalties. We will also have powers to detain and seize or even forfeit certain vehicles. These amendment proposals have been derived through close discussions with stakeholders. We have already held 2 briefings to brief stakeholders on the amendment proposals. We have in general received support from stakeholders. We will soon commence a 1-month public consultation period, and we will introduce the bill within this year into the council to hold stakeholders or various parties accountable. I believe with concerted efforts, we'll be able to create a safer living environment for citizens. Thank you, Chair. My team and I are more than willing to answer members' questions. Thank you. It's now time for members to speak. I will read out the order in which members are going to speak. Mr. Lau Kar-Kang, Dr. Thomas So, Mr. Chan Ha-Kan, Ms. Carmen Khan, Ms. Elizabeth Kwok, Ms. Kwok Foo-Young, Mr. Dennis Leung, Mr. Chen Yong, Mr. Yu Pat Leung, Mr. Andrew Lam, Ms. Christine Fong, Mr. Ken Wong, Mr. Eric Yim, Mr. Chen Hop-Fung. All right, first to speak, Mr. Lau Kar-Kang. We have 15 members who press the request to speak button. I will assign a 3-minute time limit. Questions and answers included. If we have more time, I will allow for a second round. Mr. Lau Kar-Kang, thank you. The regrettable experience of Wangfu Court fire has urged some reflections, and the administration proposed 6 pillars in amendment proposals covering different areas. I support them. I have some concerns, however. I want to talk specifically about paragraph 7. If RFSIC's registered fire service installation contractors need to shut down any major FSIs for a sustained period at late night, they must apply for prior approval. Since during the small hours, people are less alert, would we have some guidelines from the Bureau or the department to have non-emergency works done only during daytime, and they must make sure the installations work during nighttime? This should reduce risk to a very low level. Paragraph 7 also talks about there being a pre-approval mechanism. Would the Bureau consider having explicit requirements that not all buildings in the same estate can have installations close at the same time, shut down at the same time? We should have phased implementations such as installations turn off for every floor or every 2 floors so as to control the risk. After proving relevant application, if there are special reasons pushing back the works, would people have to make applications again? I want to also talk about paragraph 29 and 30 about management criminal liability, but we really need to have a definition on neglect and omission agreed with the trade so that they can understand and comply with such requirements. Thank you. Mr. Tang. Thank you, Chair. We talked about a report or notification having to be made for nighttime, because when we have maintenance works during the daytime, we have the maintenance workers there. We also have the security guards and property management personnel there. So it is relatively low risk. We don't require a notification. But then we do understand certain works can't be done within the same day. For example, if they have to dig up some tiles, it's not that they can do it on the same day. So we do allow for them to have works done overnight, but the Fire Services Department officers will conduct assessments and put in place additional measures. For example, they will ask for fire extinguishers to be done and management officers to be deployed to monitor the situation. As for whether we have an phase implementation approach, whether we should mandate it, but we do understand sometimes, for example, hoses are connected to different floors, so it may not be feasible, but we propose to have implementation done separately as much as possible. As for what you said about neglect and omission, these are common terms in legislation. For example, omission, one is not exercise or one is not fulfilling their responsibility. I believe there is a very clear consensus in law. Thank you. Dr. Thomas So. Thank you, Chair. First of all, I would like to thank the Bureau for amending or proposing amendments to relevant legislation. I want to ask about paragraph 18 in particular. It says the proposal is not expected to impose significant additional costs on property management companies or pressure on management fee levels. My personal assessment is that because there is much more work to be done by property management companies, or at least they will take this perspective, it is possible that they will increase the management fees. I want to ask if the Bureau will put in place any measures or regulate this to make sure property management companies will not increase management fees in response to the in response to the amendment proposals. I also note that with the amendment proposals, a lot more work has to be done by the Fire Services Department. For example, there's prior approval mechanism for fire service installations. There's also a notification mechanism that would require deployment of FSC officers for inspection. And I know the estimates in 2026, we have 259 posts deleted under the establishment of the department. How can the Fire Service Department meet the additional workload?
Thank you for your questions. Thank you, Chair. First of all, in this paper to the LegCo, we have laid it out that we have talked to the profession and trade. What we request them for most of the work, it is already ongoing right now. But now we are using it, making it a statutory requirement. So, in fact, what they should carry out as work is being carried out. For instance, in the past, every year annually, there will be a testing of the alarm bell, and now it's going to be half a year. So it will be very limited in terms of extra commitments or work. And in this regard, we have already talked to the Association of Property Managers, and they already have a spokesperson who said that there will not be a lot of increase of their workload. So that's one. So these property companies will not have the excuse to say that they want to increase a management fee because of additional work. And also, there are fines and penalties. These fines and penalties, where they are meted out, will be borne by the management companies themselves and not passed on to the clients. And also, secondly, yes, there will be more work, but and of course our resources is not limitless. The government has limited resources. So for the procedures, priorities of work will have to be reset so that as we assume extra work, it would not interfere adversely with our firefighting work. Any other questions from you, please? None, Chairman. Next question, Chen Hakan. Chairman, I have a few questions that I would like to see clarification on. First of all, for the post notification to prior gatekeeping, I am in agreement to that. There are 9 types of installations for firefighting where during the night or for sustained periods of time, it has to be closed down. Then 3 days ahead, there will have to be an application. And then the FSD will decide whether there is going to be an approval. Now, my question is, why within the daytime, if the installations are to be shut down for a period of time, you don't need prior approval? Because a lot of fires actually happen during the daytime and they're with grave consequences. So why not daytime as well? And also in the paper, it says for a period of time, it seems to be too general, or sustained period. It's too general. Would you specify the duration of time? The second question, we see that the owners, occupiers, if we see that there is no application made to the FSD, what then? Do they call up the FSD, notify the FSD what to do? Is it specified? Thirdly, the FSD for a long period of time, they have been very tight in terms of manpower. And now you are proposing that there is going to be a round of inspection every 7 days. Would the government perhaps add more and manpower to the FSD for their frontline staff? Do they need to come to the government, to the LegCo for further funding, or will there be different deployment within the department? Well, the reason why we need notification if there is shutdown during the nighttime, it is because during the daytime it is a shutdown for a short period of time for maintenance. And very often there will be the staff of the contractors on hand in the daytime, and also the guards or watchmen would also be present, and the residents would know of the maintenance, so the risk therein would be lower. So we want to balance the risks, and daytime risk is low. Second question is about manpower. As I have mentioned in my previous answer, indeed it is true that there will be more work involved, but through workflow optimization and consolidation of certain work and prioritization of work types, it will not affect adversely fire prevention and firefighting work of the FSD. As for the 7-day review, it is not equivalent to 7-day inspection. There are situations or cases where it says that there is no inspection in 7 to 8 months. That would not happen. But 60-day would be the limit for per institution. What about manpower, please? Yes, on the question of manpower, as I've mentioned earlier, through redeployment, prioritization or reprioritization, this workload can be taken up. And where there is a need, we'll go to the government and the LegCo. Next, Carmen Kan. Thank you, Chair. Of course, I very much welcome this proposed amendments to the FSO and the regulations. Indeed, it is true. After the Wang Fuk fire had taken place, everybody is very saddened. And we do see that the Secretary for Security is leading the task force for strengthening fire safety governance. And also we see that the ordinance and the regulations, where they are weak, we hope that through this round of amendments, it can be amended fully rather than to making it piecemeal. All those areas which should be strengthened will be strengthened, such as a question just now, why only nighttime? Do we need pre-approval? And the answer was clear. So the public would want to understand more, and I'm sure it's Cap 95 referring to the installations. It is about those installations, but there are other more passive installations, for example, the smoke prevention doors, etc., which is not and other installations not necessarily under the FSD. And also we see that there are other departments and bureaus which will also be amending their ordinances and regulations as well. So it is not just the FSD. So we want to have a full picture, a complete picture. Now, another question concerning the fueling. Now, taking this particular opportunity, there is a proposal to combat illicit fueling. Now, the penalty is $1 million, and now it is proposed that the buyer as well as a seller will have to be penalized, and it seems that it is quite hefty in terms of the penalty. Mr. Tang, thank you, Chair. Concerning the amendment of the ordinance, for the typo incident, we see that there are areas where the ordinance need to be amended, and we are proposing that in full. And for the illicit fueling activities, we think that there is high risk for our society, and therefore we are putting it into this round of amendment as well under the Fire Services Ordinance. Now, for the proactive action, for example, the alarm bells and also the smoke prevention doors and the hose reels, etc. Well, for the FSD, it is responsible for hose reels, and the fire bells, and the other departments may be responsible for the doors, etc. But at the end, ultimately, the FSD is really responsible for fire prevention. So we have the responsibility to ascertain that we not only propose some of the measures for fire risks, but also we are to follow up with them. This is the way we take it, even if some of the installations come under the ambit of other departments and bureaus. Now, for illicit fueling, It is 1 year imprisonment and $1 million in terms of fine. That is a proposal now. And for buying of illicit fueling, it is 6 months imprisonment and $100,000 in terms of fine. So, of course, not paying the duty is, of course, illegal. But at the same time, it is providing real serious risks to public safety as well. And that is why we are, increasing the penalty to 3 years and $3 million. And for the buyers, they really should not be buying this kind of illicit fueling. So we are raising the penalty up to $1 million. And we think that this is only correct. Next, call for Elizabeth Quat. Yes, Chair. In order to raise the efficacy of the FSO and the powers of the FSD, I'm in agreement to the proposed amendments and the 6 pillars therein. Now, earlier on in this committee or panel, we have discussed the most effective or the newest measure for fire combat is using technology. And at the time, the response from the administration was that the buildings use the latest technology, such as IoT, Internet of Things, to monitor fire or to discover any fire hazards. And I see a lot of amendments that are proposed to the FSO, but it's very much about increasing the liability of the owners and also the property management companies. But have you thought of incentives to encourage the management companies and the owners to install as soon as possible IoT and smart fire devices so as to monitor the safety against fire? And do you have any award or incentives, systems, and also perhaps to streamline certain schemes so that the property management companies community can adopt technology? Yes. First of all, the safety of buildings is a responsibility of owners, but we understand that there are those buildings without the relevant setups and also where buildings are occupied by many old people. Now, the government does have that scheme for incentives, but really the FSD would not have its own. Now, as for IoT, fire alarm system, the law prescribes that this can take the place of fire hose reels. And we definitely encourage this and we do publicity because these IoT devices, once they are installed, you do not have to report to the authorities. It automatically detects fire hazards and they automatically notify the FSD. So that saves a lot of time. And just now it's been asked whether there can be incentives or awards and accolades, etc. Yes, indeed, we can consider this. If something that's done and it's not required by the law, in fact, we can consider these. Chair, yes, some of the properties do not adopt technology, even with incentives and accolades and awards. So in the long term, we need to legislate for this.
Ms. Kwok Foo-young, thank you, Chair. I very much agree with the amendment proposals. It will enhance governance. It also enhances safety in the community. I have 2 questions. About paragraph 17, property management companies will be mandated to conduct annual fire drills. For professional property management companies, it should be fine. But then in the community, we have a lot of buildings that do not engage property management companies. They do not even have incorporated owners, such as the 3 new buildings. So with these buildings, objectively, they can't conduct annual fire drills. How can the government intervene to help the owners? How can we plug the loopholes in fire safety with these buildings? Second, about illicit fueling activities, we indeed have rampant activities. We have already doubled the figures of the same period this year compared to last year. The Bureau has done much in enforcement. In terms of enforcement, we do encourage citizens to make reports, and the department should conduct investigation and take enforcement action right away, ideally. But we heard some citizens say when it involves multiple departments, such as the Customs and Excise Department and Police Force, they want to know how things work. They want to know, is it the case they call the Fire Service Department and it would be done, or will they need to call some other departments to make reports? Thank you. Secretary. Thank you, Chair. On the issue of conducting annual fire drills, if the building does not engage a property management company, there is no legal responsibility in this regard, but we do encourage the new building owners to conduct such drills still, even without a property management company engaged or incorporated owners. We also have the District Fire Safety Committee that will help three new owners to conduct these drills. As for illicit fueling activities, we have a FSD hotline 5577-9666. It is a one-stop hotline. If there's something wrong, you can make a report on the hotline, and the Fire Services Department will follow on this. One may not know whether the fuel is duty paid or not. Doesn't matter. The Fire Services Department will follow on this. If duty is not paid, the Fire Services Department will also refer the case to the Customs and Excise Department. The Customs and Excise Department also has an intelligence network. They will be monitoring the flow of duty not paid or illicit motor spirit. The Customs and Excise Department, when they conduct operations, will always involve the Fire Service Department because there's always this fire hazard. Thank you. Mr. Dennis Leung. Thank you, Chair. I want to focus in particular on Pillar 3 of the amendment proposals. We'll be reforming the RFSIC registration and disciplinary regime. Right now, we have a permanent registration regime. Afterwards, registration will have to be renewed every 5 years. So is it the case that all existing registered contractors will have to register so as to comply with the new requirements? As we will have renewal done every 5 years, will the Bureau or the department take a stringent stance in registration? How can we help building owners select the right contractors so as not to have any confusion or trouble with engaging relevant contractors? Right now, with the FS251 certificates, the deadline in submission is 14 days. The Bureau didn't mention specifically how much the time will be shortened. Will we have it submitted within 24 hours or 48 hours so as to protect citizens' safety? Thank you. Secretary. Thank you, Chair. With the registered contractors, they can continue with their operations, and 5 years later, they will have to renew their registrations. When considering whether to renew registrations, we will look at, in the past 5 years, whether the companies had any incompliances and whether their major personnel, such as QPs, had any incompliance instances. These are what we'll consider. For example, the disciplinary board has already uploaded information on incompliant contractors. Citizens will be able to look up such information on the specific website. Right now, with the certificate submission of the FS 251 certificate, we propose a period of 5 days, but when we discuss with the trade, they have raised concern. They are worried 5 days would not be enough. We would make a decision after the public consultation period, but we believe it won't be 14 days because this is the deadline for paper submission. If we have electronic submission, the period will definitely be shorter. Thank you. Mr. Chen Yong, thank you, Chair and Secretary. We very much support the amendment proposals because we don't want to see another incident like the one in Taipo. We are trying to plug the loopholes here, and I have received feedback from many MPC deputies as well as CPPCC representatives raising their concerns and expressing their views. I note that in the paper, the term protection gap was mentioned. It is about how contractors or property management companies said when they have not met certain of their responsibilities, they would only be fined $6,000. Is it too insignificant of an amount? Or after all, we have inspections in the mechanism, but then often that is passive. How can we have proactive and random inspections of, say, certificates so as to catch the incompliances? Actually, many deputies mentioned this. With the fire and other instances, we have seen the Fire Services Department officers not able to catch incompliances because they would conduct passive inspections. We'll be holding property management personnel and owners accountable, but we need to make sure there is a safety net. The government departments would have to be involved. We want to take a more preventive approach. Obviously, the Fire Services Department will have expertise in this regard, but we should also have other departments help to have a tighter safety net so that we will not have that many gray areas and we'll be able to plug the specific loopholes. Secretary, thank you, Chair. Mr. Chen mentioned some fixed penalty amount $6,000. There are also $1,500 and $3,000, but this is just the fixed penalty fines. But we can initiate proceedings in the form of issuing summons or even criminal prosecution. The fine levels will be much higher. There may even be a prison term. It is only with the least serious cases that we will issue fixed penalty notices. We do take a risk-based approach with inspections. We also take an intelligence-led approach. Some people making reports, we will follow up on those. We also inspect proactively buildings undergoing major repairs. We also have FSC officers conducting inspections in plainclothes now. We found this to be quite effective. As Mr. Chen said, eventually the Fire Services Department will be responsible. If citizens don't know which department is responsible, as long as it's related to a fire hazard, the Fire Services Department will inspect it and deal with this, and they will make referrals if necessary. But even after making referrals, the Fire Services Department will still follow up on the relevant cases. Thank you. Mr. Yu Potlang. Thank you, Chair. I believe the amendment proposals will enhance fire safety in Hong Kong. I have 2 questions. For Pillar 1, as some members said, there will be additional administrative work with the amendment proposals. For example, for the Fire Services Department, we have prior approval mechanism. If contractors have to shut down fire services installations, they have to make an application at least 3 working days in advance. With the approval process, we will need manpower. Do we have enough manpower? Would we have some sort of a service pledge from the Fire Services Department to the contractors in terms of how much time is needed to give a reply to contractors? In Pillar 2, we will introduce the FSI, responsible persons regime. I think it's good that we will have property management company personnel become gatekeepers. But then, with the Fire Services Department, they conduct inspections. Citizens will be very compliant, but then if security guards do the same, the people may not be as compliant. They may just put things out right away after security guards leave. So how can we make sure, even with such instances, property management personnel will be empowered to conduct such inspections and take forward their work? Secretary, thank you. The Fire Services Department will try to deal with things as much as possible, but if we need help, we'll definitely ask for it. Right now, with the different licenses, we have already some outsourced part of process that has helped save some manpower. We also will change the submission method of certificates to electronic. This will also help save some manpower because the data don't have to be keyed in. The service pledge is that we will have an application made within 24 hours. We'll have FSD officers deployed to conduct inspections. With property management companies, they have the responsibility to conduct inspections and make records after inspections. And if they have seen some sort of obstruction, they need to make a record of such. And if people are not compliant, they can refer the case to the Fire Services Department, and the Fire Services Department may issue a fixed penalty notice or a fire hazard abatement notice. In a way, it is more convenient for security guards now, because now they must make a record, and this evidence can be quite useful in initiating proceedings in future. Thank you. Mr. Andrew Lam. Thank you, Chair. I want to talk about the responsible persons regime. I think this is good. And when I heard the Secretary speak, I think the regime is quite comprehensive. I appreciate that. With buildings, daily management and repairs, it involves many different people, responsible persons in a way. And with the division of responsibility, I do appreciate what the Secretary said. But we need to have clear code of practice under the amended legislation so that property management companies know what the workflow is. It can also help owners, making it clear that what their legal liability is. I think making the submission process of FS 251 certificates electronic is definitely a good thing. I just want to ask, with the submission of such certificates, it is only when something is wrong the Fire Services Department will get back to the management companies or owners. 3 new buildings would be an exception. How can we have an electronic platform that is available for stakeholders or parties to inspect such information? Can we have some sort of code of practice made public? We want to make sure responsible persons and relevant companies understand what is going on. Thank you.
Thank you, Chair. Thank you for the questions. Now, apart from the ordinance and regulations, we also have a code of practice. We've always had that. So after the ordinances, etc., have been amended, we will put in the changes into the code of practice so everybody is clear as to their requirements. Now, as for the FS251 certificate, right now these have to be mailed to the FSD. Right now there's a lot of disputes. Some say that the certificate or the application had been sent to the FSD, but we have never received it, and there are delays because of input. In the future, this won't happen because it will be all digitalized. And also the relevant contractors or the companies can post the QR code in a prominent location in the building. And so the residents will be able to verify that very easily. Thank you. Christine Fong, thank you, Chair. For Chapter 95, we welcome this 6 pillars of amendments. I'm in support of those. Just now, it's been mentioned the FSI notifications. I'm looking at this notice, actually. If we can put the QR codes on this FSI notice, this red notification, I think is very useful for the community and for the occupiers of the buildings. If they know, the residents know what installations are broken, not working, that would be good too, so that they can continue to monitor them. Now, for the installations where there are reasonable doubts and that is brought to the attention of the FSD may require the responsible person to commission contractors or qualified contractors to conduct inspections. So are there fixed fees, for example, where the estates or some third-party independent contractors, you have a register for them? And there are, let's say, for CPH, for example, there are fixed fees such as $17,000, what have you. So where there are these problems and issues, I think perhaps we can consider that. So I am in support of this in principle. It's just in operations. We can deliberate further. And also digitalization is indeed more convenient, but can we extend on it? Let's say for certain inspections, the staff of the contractors may have to go to 2 to 3 sites for inspection. So how long can they stay in one building or site? So this digitalization, this platform, perhaps it can be extended in terms of function to mark also how long the staff or personnel had stayed on the site. Now, for illicit fueling, for the legal fuel vehicles, will there be labels for these vehicles to show that these are legal sanctioned vehicles? So where they are at these legal sites, these vehicles, but en route they go to an illicit site, people will be able to notice that. And I am in support of the imprisonment terms, by the way. Thank you, Chair. Thank you, Ms. Fong, for the suggestions. Yes, to add a QR code on the notice is a good suggestion. Now, further, for the installations, there is a label on the device as well. The broken or non-functioning device will be given a label so that the residents will be able to know very readily. And also for the contractors, they are able to find the register of these RFSIC, the contractors, on the digital platform, on the register, but the fee will not specify. Now, also for the fire installations, it's not like we review that anyway, but rather where there is a contractor which has major disciplinary action against it, or they have handed in some falsified certificates, etc., and our staff are suspicious of this consultant, only then will we ask another consultant, or we serve a notice to the responsible person to have another contractor do the inspection. Now, another question, a lot of companies have gone digitalized, actually. Digitalization is easier for operation and control, and we do suggest digitalization, and it's easy for future referrals as well. Your last question concerns illicit fueling. So there are vehicles which are legal vehicles for transporting fuel, and all these are given a license and label already. Yes, Chair, Ken Wong. Thank you, Chair. For CAP 95, the Fire Services Ordinance, it is very important for safeguarding the safety of the public. So I'm in support of this round of amendments. I'm looking at paragraph 20 of the paper about responsible persons and strengthening the qualification requirements for these QPs. And it talks about the academic qualification of the QPs. Is there a transition period, and are there exemptions? And these qualified persons, if they do not attain the academic qualification at present, what would be their registration be? And also the CPD 30 hours regime. Do we already have the specifics therein concerning the professional development, please? Well, thank you, Chair. Thank you for the questions. The present proposal is as follows. First of all, there will have to be a diploma at the least. So there will have to be a bachelor's degree level. The current requirement is diploma or higher certificate level. We are raising that to bachelor's degree level. And for the transition arrangement, it is that the existing practitioners will be recognized. So they do not have to go for a bachelor's degree or increase their academic qualification in order to be eligible. As for the 30-hour CPD, in the future, we will have a code to specify which courses will be admissible as constituting part of the continuing professional development 30 hours requirement. So this will be much like the CPDs that we see for other regimes. Any other questions? None. Next, Chris Ip. Thank you. Thank you, Chair. I'm in support of the amendments, and we want to see this come to commencement as soon as possible. Now, concerning the buildings with no owner committee, no property management, etc., the so-called 3-nil buildings, I'm just worried that very often it is the fire prevention committees are made up of people in the community, and it's very much about publicity and education work in the past. Now, for fire drills, is it right for them to be responsible for this? I'm concerned. Through this amendment, actually what we want to achieve is to enhance the public's awareness and work on fire prevention and firefighting. So would there be targeted efforts to help these buildings, 3 buildings? Another question also pertaining to fire drills. I think for residential buildings and commercial buildings are different. For the latter, it would be focused on work hours. But for residential buildings, for there to be fire drills, because the residents will have different times of work and rest, so the drills would probably be conducted in the nighttime. I'm just wondering, will there be appropriate times and arrangements for fire drills so as to make it more convenient for the residents? Thank you, Chair. For this Fire Prevention Committee, it is to coordinate the efforts. As you have mentioned, these are community members. They do not know how to register what the congregation areas would be, etc. So this is actually work to be taken up by FSD itself. The committee is only there to coordinate. As for the drills, we will have a practice code as to the objective of the drills, and there will be notifications pre the drill, and also the route of the fire drill, etc., etc. So there will be a code of practice. Any supplement, please? Now, I'm looking at paragraph 18 of the paper. It talks about statutory duties. It's been mentioned that the profession had been communicated with. Now, for the bigger estates, indeed, the pressure for increased fees would be low. But for the single buildings, standalone buildings, the pressure will be much greater. So please pay attention to that. Thank you. Eric Yim. Thank you, Chair. I'm in support of making it more stringent for fire services requirements for the public safety. I have two questions. First of all, the property management companies for conducting fire drills, they have been following the original regulations, and it is not mandatory in requiring how many residents or how many households participate in the drills. Now, if it is made mandatory with the new amendments, would there be a requirement as to at least how many % of the residents or households participate in the drills, so that sufficient amount of residents would know what to do if indeed they need to escape from fire? So will there be this enhanced requirement? And also concerning paragraph 20, concerning the strengthening of the qualification requirements of the QPs, for these QPs, qualified persons, in installing fire installations or monitoring or supervising others to do so, on the one hand, there is an increased requirement, and there are certain legal liabilities involved for these QPs in such work. Would it result in, with this requirement coming into commencement, would it result in some of the existing QPs exiting the industry? And if so, in the future, would the cost for installation of such be increased in the future? So in the future, would there be certain exemptions where the contractors are purchasing the fire installations, and in the paper documents, if it is mentioned that the persons are qualified, but on the other hand, if the purchased installation or the firefighting device is actually a false one, but this QP had made the installation. What then?
Secretary, thank you. For the first question, whether we will include the number of people that must participate in fire drills in the code of practice or guidelines, I think it's very hard because we have different circumstances. Some buildings may have more elderly residents. We won't expect every elderly resident to participate in the fire drill. We want to make good use of public education instead on raising awareness of evacuation arrangements. As for QPs, we have strengthened the qualification requirements. We need people to be university graduates before, but then now we actually don't have specific degree requirements. As long as they have relevant experience, we actually have a larger talent pool compared to before as a result. How about the question on defense provisions? Well, I think we have to be reasonable. As a professional acquiring an alarm system, one should be able to tell whether it's authentic or fake. Well, some are quite good lookalikes. I understand. Of course, it would have to be reasonable, and we need to prove that it is reasonable before we can initiate prosecution. There may not be defense provisions, but there has to be adequate evidence in the first place for prosecution to be initiated. Thank you. Mr. Chen Haofeng, Deputy Chairman. Thank you, Chair. The Secretary said with the property management personnel being held accountable, it will not incur additional costs because property management companies are already doing relevant work. But then another cost may increase. That is the fire safety annual inspection costs. Most of the systems, including the alarm system, will have annual inspections before. But now you're asking for inspections to be conducted every 6 months, so there will definitely be an increase in costs. Or is it the case that according to your assessments, the cost will not increase? With the increase of penalties, it means more stringent regulation, but then citizens are not aware of the specific provisions. I think with you uploading information about incompliant contractors online, it can definitely help. But then I have another question. With renewals done every 5 years, that is quite a long period. Why not have the period be 3 years or even shorter? What are your justifications for setting the period to be 5 years? I also want to ask about the disciplinary mechanism. Are we accumulating demerit points so that with different kinds of incompliances, there will be different points accumulated? How can we make clear such information to citizens too? Thank you. Secretary, with annual inspection costs, it can range in general to a few $100s to $2,000 to $3,000. So I don't think it's a lot for the whole building. This is the cost. So I don't think it will affect management fee levels much. As for the renewal period being set at 5 years, it is the same for lift and escalator technicians, for example. We have set the period to be the same as these technicians because we think the importance and there's some is similar and that there are other similarities. As for the accumulation of demerit points, we will also refer to the practices for other trades. Thank you. Mr. Tenkapu. Thank you, Chair. adopting a multi-pronged approach is appreciated. We have different stakeholders being held accountable, contractors, property management sector, as well as the Fire Services Department. I want to ask, for the property management sector and the fire services installation trade, how ready are they for these amendment proposals? We will have clear accountability for them. They would have to fulfill certain professional responsibilities. Have they conveyed any difficulties in compliance? I do very much support also the permanent registration regime being converted to a renewal regime. According to your assessments, are there contractors who may not be able to meet the renewal standards? We'll have renewals done every 5 years. If you have renewals done every 5 years, it can be quite a significant workload. Will you have phase implementation or specifically phase renewal? We also have people who may not be able, who have hearing impairment, who may not be able to hear the alarm systems ringing. We have in housing society or housing authority estates alarm systems with flashing lights that can help, but for private housing estates, they may not have that. What is the FSC's recommendations for these buildings and estates? On illegal fueling activities, I do agree that we should have stringent enforcement stance against sellers, but should we have harsh penalties for buyers? I have some reservations, but I guess we can wait until we hear feedback from society. Thank you. Secretary, thank you. We have consulted the property management sector and the FSI contractors. They do support the proposals. The reforms may sound harsh, but we have already been doing much, and we have promulgated the requirements in the code of practice. Now we have just made them into statutory requirements. I think in general, stakeholders support this. There are just some discussions, for example, with what I said about the period for submission. In principle, there is really nothing they disagree with. About the renewal period being 5 years, it does not mean that we will only review things every 5 years. If there's any incompliance, we will still conduct disciplinary procedures. We can still revoke their licenses or suspend their licenses if necessary. It's just that we have introduced other forms of punishment so that we can perhaps fine or have some sort of financial penalties for the contractors. We have for buildings completed after 1994 to have some visual alarm systems. For buildings completed before that, we do also encourage them to have visual alarm systems installed. About illicit fueling activities, we suggest buyers to exercise prudence. We have had explosion incidents in Changsha-wan and Tokwa-wan. There were some serious injuries. The vehicles were burnt. We want to combat illicit fueling activities. There is always a legal responsibility, specifically with the use of duty not paid motor spirit. So we ask citizens understand the hazard and damage caused to society and not buy duty not paid fuel. All right, we have 16 members who have spoken for the first round. We have Ms. Carmen Khan wanting to speak for a second round. Are there other members who would like to speak for a second round? If not, Ms. Carmen Khan, you may speak for a second round. 3 minutes. Thank you, Chair. I want to follow up on the introduction of management and criminal liability. In paragraph 30, it says specifically if there is consent from the management or there is connivance or neglect of the management, they will be held accountable as that is the senior management personnel will be held accountable. We have included neglect and omission specifically in the amendment proposals. I think we need to make sure with eligible personnel, for example, authorized personnel of registered contractors, they should be covered. If they've neglected things or omitted things, they should be held responsible. But then you are enhancing the coverage of responsible persons to property management sector. Will we have the same standards for the different sectors in neglect and omission? I understand this is quite technical. We don't have the blue bill here just yet. I understand you have referred to the Chapter 572 on the fire services building safety related legislation. I just want to ask specifically, when people turn a blind eye and there is some sort of negligence or risk, how will you define this and what standards will you adopt? Secretary, thank you. After the Wangful Court incident, we have reviewed the situation of works. We have found that some management personnel of companies know their subordinates are not doing certain things or are doing something wrong. They know that, but they just didn't do anything about it. We think they should be held accountable. It can be some form of negligence, but then with we saying consent or connivance, there is some proactive, but with neglect and omission, we want to cover the more passive cases. In fact, in the Wangful Court incident, we did identify some of such scenarios, so we want to cover those scenarios as well. Ms. Carmen Khan, anything to add? I just want to ask some follow-up questions. With the laws, will you cover responsible persons that you have recently proposed to enhance coverage for to cover property management sector and FSI contractors? We cover mainly the management personnel of companies. It has nothing to do with owners of the buildings or units. I would like to say something. I support very much the amendment proposals. I agree with what Mr. Tenkapu said. I want to remind citizens not to buy duty not paid fuel and thereby encouraging illicit fueling activities. If it is not profitable, people will not do it, and it can be very hazardous, such activities. With the increase in penalties, I think we should have harsher penalties for the users as well. People will know it is illicit fueling because they are not fueling at petrol filling stations, so there's really no way around it. This is just a comment. Thank you, Secretary. Let's move on to the next agenda item. The next agenda item is work on combating illegal employment. I will now invite relevant representatives from the administration to come inside the conference room.
好啊，我哋歡迎保安局副
We welcome Mr. Ng Cheng-yin and also from the Security Bureau and also from the Labor Department, Mr. Ho, and their teams to be here. First of all, let us bring the members through the paper. And for those members who want to ask questions, would you please push the buttons now? Next, we will have Mr. Chuck bring us through the paper. Thank you, Chair. The Security Bureau will be bringing you through the work progress on combating illegal employment. This is about combating illegal employment and also protecting the employment of local people in Hong Kong. This is a very grave offense in terms of illegal workers, employers, as well as aiders and abettors of illegal employment. Compared to 2024, there had been an increase of 12% in terms of enforcement activities against this regard. And we have, during these operations against illegal workers, there had been a total of 1,264 legal workers and 569 employers arrested. And also, in September, there had been a cross-departmental task force set up, and a number of enforcement authorities and policy bureaus are involved, and they include the Labor Department, and the Labor Department is represented and right here in this meeting. This task force has closely monitored the crime trends and adopted a multi-pronged strategy in implementing a series of measures against illegal employment, including collaborating with the mainland authorities and enhancing intelligence collection, enforcing laws rigorously, and providing education, etc. The IO was amended in 2021, increasing the penalty of employers employing prohibited employee with a maximum penalty significantly increased from a fine of $350,000 and 3 years imprisonment to a fine of $500,000 and 10 years imprisonment. Over the 3 years past, convicted illegal workers had been sentenced to a maximum of 19 months imprisonment, and convicted illegal workers were sentenced to a maximum 23 months imprisonment, and employers sentenced to a maximum of 19 months imprisonment. The sentences reflect the gravity of the offenses, and we believe that the prevailing legislation already has a considerable deterrent effect, and the department will continue to closely monitor the sentences and seek DOJ's consideration and opinion where there is a sentence review necessity. And also in the regard of ride-hailing services, including platform vehicles and drivers providing ride-hailing services, there had been a number of new ways to report such offenses. For example, it is already available a hotline dedicated to reporting illegal workers, and it is also available as a reporting means on WeChat and I'm Smart, and there is a reporting hotline launched in March 2026, 185, and also we will have decoys operations to combat these illicit or illegal employment situation. From 2025 to end of March 2026, the Immigration Department had conducted 41 decoy operations with a monthly average increasing by 145% as compared to that of 2024, with 46 illegal workers and 4 employers or aiders and abettors arrested. During the Golden Vacation Week, there had been a new round of action to combat illegal employment. And the Immigration Department, the Police Force, and the Labor Department have this task force set up to exchange intelligence and coordinate inspections to fight illegal employment. And from October 25 to March 26, there had been stepped up enforcement efforts, conducting nearly 12,000 enforcement operations with an increase of 30% over the past period of time. And during these operations, 622 illegal workers and 256 employers were arrested. And also, for mainlanders who have been convicted of illegal employment, from 2 to 5 years, the mainland authorities will not issue the exit endorsement to such persons so that they are prevented from revisiting Hong Kong for illegal activities. And also, we have actions against platforms which advertise online about employment opportunities in Hong Kong. And we, through exchange of intelligence with the mainland authorities, they follow up with actions whereby such posts are taken down. And further, for certain visitors to Hong Kong, we're working with the Immigration Department where they have doubtful purpose of visit and are frequently visiting Hong Kong with suspicious reasons. We will take action and refuse their entry where necessary and appropriate. And at the same time, we step up with publicity and education work to increase the public's understanding of criminal liability, employing illegal workers through various channels, and also for domestic foreign helpers and visitors through various means and through the consulate generals of the various countries. We are stepping up with the publicity and education work. The task force will continue to closely monitor the crime trends in illegal employment, formulate and adjust our responses in a timely manner, and continuously combat illegal employment to safeguard employment opportunities for our local workforce. Thank you very much. We have 7 members who want to ask questions. They are Charles Yu Chung, Andrew Fan, Dennis Leung, Yu Pak Leung, Eric Yim, Carmen Khan, Chan Hock Fong, Vice Chair. Mr. Charles Yu Chung first. Thank you for the opportunity, Chairman. Now, combating illegal employment is very important. Now, we have sufficient time, so let's have 4 minutes Q&A. Yes, this present term of government is very adamant on combating illegal employment with a new hotline and a new task force, and these are commendable. Now, paragraph 6 of the paper, and it was brought through, we were brought through that. It says reviewing of the penalty, and for the employers, the highest maximum imprisonment terms is 19 months. So that's a year and a half. And it's less than 1/5 of the maximum imprisonment terms. Does it reflect the severity or gravity of the cases? What is this case involving 19 months imprisonment? It's actually a company for dishwashing, and there were over 24 illegal employees who were sent to 7 restaurants. So this is a organized work. And this is definitely serious. For these cases, if the employers, of these illegal workers were only sentenced to 19 months imprisonment, I don't think this is commensurate. For the illegal workers, the maximum imprisonment is 24 months, and in the past years it's gone to 23 months as a sentence actually meted out, and this is near to maximum. So I think this is a little bit imbalanced. 19 months seems too low, and there needs to be a certain review. Secondly, for combating food delivery services. For these platform companies, for food delivery, are there indications or handling measures or actions against them because they will not have any incentive to step up with their vetting process because if they do, that is, step up with their vetting process, it may bring them problems in hiring people. And also for illegal employees, they're everywhere. And in terms of the renovation businesses, many of them actually are working indoors within units. And it's very difficult to investigate. We have heard that there would be closer liaison with the property management companies so that they can do their work better. So is there any progress in this regard with regard to the property management companies so that they can increase their inspection in gate keeping so the illegal employees cannot go into the housing estates to conduct work? So 3 questions. Thank you, Chair. First of all, concerning the delivery services platform, what are the work therein? I will ask the relevant department to answer the question. Now, in terms of the sentences for each of the cases, we will look at the court sentence, whether the penalty is severe enough. It is too light, we will apply for review at the court. In the past 3 years, we have done so 7 times. And for each case, it is indeed true they have their own characteristics. And the court, in considering the sentence and penalty, apart from considering considering the severity of the offense, but also the personal background and characteristics of the offenders would also be considered by the court. But do be assured that we look at the sentences and penalties to see whether it is commensurate, and we will ask for review and where appropriate. Now, for some of the buildings that are newly moved in, we actually carry out proactive inspections for illegal employment. Let's say there is a light renovation, let's say changing an air conditioning unit. For these instances, it is difficult to detect. We work together with the property management companies because on entrance and exit, they will have to register their identity. If they do not have a valid ID, for Hong Kong, this should be noted by the property management companies and we can follow up with actions. The Labor Department will talk about the food delivery platform question. In the past, we have been in close liaison with these platforms for delivery. And there had been face recognition and dynamic identification so that there is no using of other people's identity and therefore providing opportunities to harbor illegal employees. And also there had been efforts to explore the protection for workers of delivery platforms. And in particular, there had been detailed discussion on combating illegal employment for these delivery platforms. So the question was really about whether there had been any increased measures against them. Now, for these illegal employees and their coordinating partners, we actually only allow these platforms to hire legal employees. I think the point there is, for the question, is that if we are more stringent on on these platform companies, and if the measures or the sentences are very light, then the vetting of the identity of these delivery platform employees will be cursory, insufficient. So the point is to increase the penalty for such platform companies. Right, there had been a series of targeted measures against renovation-related illegal workers. There had been 870 such inspections or enforcement activities, which is some 400% more than the year before. Now, for platforms which post advertisements for illegal workers to come to Hong Kong to work as renovation workers, we have decoy enforcement activities. And also we work with the platforms to take down the posts for such advertisements. And also we are working with the association for that is the PMSA for property management companies. We do joint activities to educate the property management companies. And also for certain areas and sites, we actually remind the citizens of Hong Kong not to hire these illegal workers.
Mr. Andrew Fan, I want to follow up on Mr. Xiao Su Cheng's questions. Would delivery platform companies have to be held equally liable like the ride-hailing service platforms on due diligence? On combating illegal workers, I can see in news reports how Mr. Chris Sun has tried to be a delivery worker for food delivery platform, and we are going to have legislation for protection of platform workers. But some are concerned because for some of the platform workers, regardless of whether they are illegal workers, they have taken quite a lax driving attitude on street. They don't wear helmets, they run red lights, etc. While we're trying to enhance statutory protection for platform workers, how can we step up enforcement against instances like these? Well, you said it may be illegal workers, but it can be the case that people who are legally working in Hong Kong that can still commit crimes, like you said. But luckily, we have Undersecretary for Security here, so he can perhaps answer the relevant questions. Right, for what the members said about not wearing helmets, we do have an exemption for those who are wearing turbans. They don't have to wear helmets for religious reasons, but all other people should be wearing helmets, so it can be really obvious who are breaching the laws. As for whether they are illegal workers, it would depend on what evidence we have on hand. Undersecretary for Labor and Welfare, Mr. Ho Kai-ming. Thank you, Chair. Thank you, Mr. Fan, for the questions. The platform companies, of course, held liable in terms of management. As Mr. Simon Lee said, we have enhanced communication with platform companies, and platform companies will conduct random inspections to make sure the specific workers are legally allowed to work in Hong Kong. We see that platform companies have been more stringently making such checks because the compliance costs can be quite high. if we see platform companies allowing such breaches of the law specifically, it will be a breach of the immigration ordinance in the first place. We will make sure platform companies know what the consequences are. All right, any follow-up questions from Mr. Fan? No, I'll follow up on the relevant issue on other occasions. Thank you. Mr. Dennis Leung, thank you, Chair. I thank the government departments for hearing the calls of the labor sector, and they have actively taken enforcement action. But I note in the paper from 2023 to 2025, the number of people arrested are about 500 odd, but we don't have many of them prosecuted. Well, arrested. 2023 it's 22%, in 2025 it's 31.55%. We have also a low number of prosecution cases. In 2025, we only have a 71% conviction rate, approximately. I want to ask, what is going on? Is it something with the collection of evidence? What can we do to up the conviction rate? Now, the fines for companies, the lowest is $1,000, but we already have quite a high amount of fixed penalties for, say, littering, $3,000. Can we work with the judiciary to tell them these offenses are serious? We want to make sure there is fairness in public impression. We have some people working illegally in Hong Kong with exit endorsements for business visits. We have some in the labor sector say they don't know whether their colleagues are illegal workers. They and their colleagues come to Hong Kong every day from Macau or the mainland. So can we ask employers to announce who the employers who have engaged imported workers are, so that it would be more easy to identify employers who are hiring illegal workers instead of imported workers? Thank you. Undersecretary for Security, I will ask the Labor and Welfare Bureau representative to talk about whether there can be announcements for which companies have imported workers. Now, for premises that have hired illegal workers, sometimes we don't see the specific employers present, and it can be quite challenging to produce evidence for employers. So we have a lower conviction rate for employers because it is hard to prove that they know the existence of illegal workers, and the illegal workers are not willing to make accusations against them. We have 480,000 people coming to Hong Kong each year with exit endorsement for business visits, and we only have 27 people identified as having committed relevant offenses. As long as one is not legally employable in Hong Kong, they are illegal workers. So whether they're holding an exit endorsement is not really particularly significant. Now, I'll let the LWB representative answer the question on imported workers announcements. Thank you, Mr. Leung, for the questions. We do have some imported workers breaching employment or the conditions for entry, but that is a very low percentage. In 2025, it's 0.165%. So it is a very, very low proportion of workers imported. We don't see, therefore, there being a need to announce which employers have imported workers and the specific ratio, because it does not really help us identify which workers are legally employable in Hong Kong or not. Right, but the question regarding the question on penalties for fixed penalties for companies, it's just $1,000 to $100,000. Will we have harsher penalties? We note the members' comments. It's just like on the question on whether we'll have a prison term. We do have a maximum penalty, but we don't have a minimum penalty in Hong Kong. But as long as we think the sentence is like having regard to the circumstances, we will apply for a review of the sentence, including for a fine sentence. Thank you. Mr. Yu Patlang. Thank you, Chair. After the setting up of the interdepartmental workforce since September, we have really seen an increase in figures. In the first 3 quarters of 2025, we have seen a 30% increase. Indeed, the prosecution rate is not that high, but I think there's already some sort of deterrence. As the Undersecretary said yesterday, they have successfully arrested an individual who has illegally engaged in the work of tourist guide yesterday. The individual is a visitor, and we have seen the issue of illegal workers being quite prevalent in the tourism sector. We don't really have a representative from the Culture, Sports and Tourism Bureau in the task force. Would you engage the Culture, Sports and Tourism Bureau seeing the situation? I have another question. Another member and I have met with representatives from the Security Bureau, the Immigration Department, the Tourism Board, and the Tourism Commission on the issue of illegal workers in the tourism sector. And after the meeting, I have observed the Immigration Department working with the Tourism Board to take enforcement action during the Labor Day Golden Week this year. They have proactively conducted cyber patrols, and they have had successfully arrested individuals after decoy operations. I want to ask, will we continue to see decoy operations being conducted in non-holiday periods? We see certain suspicious individuals outside West Kowloon museums wanting to conduct visits for people. We need to combat those instances. We need to step up patrols. Will we have more of the decoy operations against this? The 185 hotline is not well known at the moment. How can we enhance publicity and awareness? I think we need to allow practitioners to make reports for effective enforcement. Thank you. Mr. Chuck. Thank you, Chair. I would first like to thank member for his support for our work. We'll definitely invite a CSTB representative to join the task force because indeed we observed during long holidays, as we have a lot of visitors from the mainland come to Hong Kong. It has created a market for illegal workers in the mainland. Let me clarify something with the conviction rate. I think the number of people arrested for illegal workers compared to employers and aiders and abettors would be lower. It's not about how we have a low conviction rate for arrested persons. We will continue to mount operations. It's not just in the specific sector. We will also target illegal workers, say those delivery workers as well as decoration workers. On publicity, we will continue to step up publicity. We'll do that online as well as on social media platforms commonly used by mainlanders. Thank you. Mr. Eric Yim. Thank you, Chair. We have the illegal worker issue observed in many different countries. It's mainly due to there being an imbalance of demand and supply of labor. Even with the imported worker scheme on care workers launched in 2023, there is still great demand in the market. There are quite a number of illegal workers. As I understand, in Singapore, they allow care workers to be imported. And can we do that to basically increase the quotas and reduce number of illegal workers? We still have a great manpower gap, especially during holiday periods. We do have in other countries such as Australia, New Zealand, and Japan, 14 countries, they have working holiday scheme. In Hong Kong, we have working holiday arrangements, but it does not cover mainland youth. As we see a significant increase in the number of visitors from the mainland, can we allow mainland university students to work in Hong Kong in, say, retail sector during summer and winter holidays? It can also provide a greater experience for mainland visitors because we can have these mainland students serving them. I have already raised this suggestion in the last term. I want to ask if the government has any plans to consider this.
就係
Thank you for the questions. Now, the theme of today's meeting is combating illegal employment, but you spoke about the supply of workers. So he's saying if there's no shortfall of workers, there will not be illegal employment. So this is something that we talk about a lot of times. Well, thank you for the questions. On working holiday, Hong Kong as an independent economy, it is something that we sign as an agreement with other countries. As a SAR, we cannot sign on behalf of the country, for instance. And we are talking to the country of Chile, for example, but it will take a little bit of time for further negotiation and also for exploration in this regard. Now, as for worker scheme for care homes, there is a special scheme for such employment, and every year there is a larger quota. And for privately run elderly homes, it is 1-to-1 in terms of imported labor and local labor. So rarely do we hear of illegal employees in elderly homes. As for the subvented elderly homes, it is 2-to-1. In terms of the ratio. So we will continue to monitor the operation of such homes, and the Labor Department will have the site visits to look at the situation of these imported labor when they come to Hong Kong, how compliant they are in terms of their working hours and in terms of their payment of salary. Carmen Can. Thank you, Chairman. And this is 3 bureaus and 4 departments which have together formed this, written this paper and also formed this task force for combating illegal employment. And that is good. I hope this task force in the future, apart from providing analysis on illegal employment, let's say 60% illegal employment from the base of visitors, but where do they come from, mainland or what other countries there's information. Now, for the main industries, it's listed here: renovation, restaurant, and cleaning. That is insufficient. I want there to be more refined data so that we can do some analysis. And I think it is a very good response just now, the questions asked, and that is if we have the sufficient supply of labor, we will not have as many illegal workers. So we need that kind of information. For example, in your categories and industries, what areas are we lacking in terms of workers? Are we competitive? And the Labor and Welfare Department already has a unit which takes care of reskilling and enhancing of skills. And that is very good. So our local labor will be able to meet the demand. And also for renovations, for example, measuring of for measurement tools, for example, selling that measurement or service of measurement. Is it illegal provision of work? For example, for cleaning service, or are they providing nursing care, etc.? I think what I'm trying to say is that if we have more transparency into that kind of data, that will be helpful. And also for unusual frequent visits to Hong Kong, I think that is information that's useful, that is gathered by the Immigration Department. Now, if you do not have that data provided to us, then we and the public would not know how effective it is. I think this number also is meaningful. Yes, Mr. Ho? Well, answering these questions, this is about analysis of data and relevant arrests, etc. Now, for the illegal workers, we have their records and their visa and their identities, etc., and we reflect the relevant information to the relevant authorities, such as to the mainland. And what areas they are engaged in, we know that too. And we will look at the trend of the illegal workers' employment, and we will be combating in a targeted manner. Yes, I agree with Ms. Khan that we need to be targeted, and we have the data and we can provide that information as well. Now, at the ports and control points, we are scrutinizing our system. Now, our system basically just register the refusal, the instances of refusal based on suspicious reasons of coming into the territory, but we do not have finer information. What about the control points with unusual entry of into the territory? As I've mentioned just now, concerning what reasons we do not allow for entry into Hong Kong, in this particular item, we just say the person suspected not to be a bona fide visitor, but therein it can be that the visitor does not have a return ticket to show at the airport. Maybe he's a holder of a false visa, etc. It's not more granular than that. Perhaps we can go back and look into this. Right. Ms. Khan asked a question about the different industries, cleaning, restaurant, etc. So we know what the hotspots of violations are, if you can provide that information. Now, as for renovation of houses or flats, what about the illegal workers providing, let's say, measurement as a service? And these are not local workers. Would that be construed as illegal work? As long as they cannot be legally employed in Hong Kong, and if the person is coming to Hong Kong to carry out work which is not admissible, which is illegal in Hong Kong, that will be an illegal worker in our books. So we would have decoy operations, and we will know, when they are engaged in such work and even what fees they charge. And also for certain delivery platforms, if they come to Hong Kong to deliver certain goods that are ordered on the online platforms, that would constitute illegal working as well. Right. This is exactly the situation we're reflecting to the authorities. Mr. So just now from the Immigration Department said that there is an increase of inspections to 400% compared to the period before, to the tune of 800 plus incidents. So there are instances where there are workers coming across the border not only to deliver the furniture or goods, they even make the measures at the flats, and even they carry out the renovation and decoration work. Definitely, that is something that need to be combated. All right, because of time, this is 4:25. There are two more members who want to speak. Let me just extend the time for 15 minutes. Next, Chan Hock-Fung, Vice Chair. Well, in recent years, it is getting harder and harder to detect illegal workers because it is organized work. And now there are individual illegal workers as well, and renovation work is also more hidden. Now, during the so-called Labor Day Golden Week, there are people who come from the mainland to Hong Kong, and they take videos and photos of the tourists as hired photographers. Perhaps the payment was made in the mainland, not in Hong Kong. So how can you combat this kind of work, and how can you actually gather the evidence against them? Next question on the number of times of coming into Hong Kong. Let's say every day at a specific time they are coming into Hong Kong time and time again. Are there such suspicious cases? Do you actually have people following them to see what they're up to in Hong Kong? Do you actually do that? I want to know. Third question. Just now, a member mentioned, can we open up mainland graduates to come to Hong Kong to work? Well, I myself oppose this because we all know it is about 10 million, over 10 million of graduates from the mainland. 4 years would be 40 million. So I am objecting these allowing graduates from the mainland to come work in Hong Kong. In answer to the question, yes, indeed, a lot of illegal work is actually quite hidden. You mentioned, the member mentioned photo taking, video taking. They are providing this as a service in Hong Kong. That's definitely illegal, and we will use decoy operations to combat this. And on site, if we actually see a man taking pictures of two ladies, for example, it's very difficult to gather evidence because we never know whether they are friends. So we very often do this online, and if for advertisements on online platforms, we will contact the mainland authorities to urge them to take down the posts involved. Now, for people coming to Hong Kong for a few times a day, because we have a multiple visits visa, so this is admissible. But at the control points, we will observe if the visitors bring tools, working tools, then we may follow up. Just a point of supplement, the multiple entries visas, at the time, members wanted more tourists coming to Hong Kong. Those people are tourists, and we wanted to encourage tourism, but not working in Hong Kong. Let's say they come at 7 a.m. and then at 6 p.m. every day, they go back, and obviously these are not tourists. And hopefully the Immigration Department colleagues will be able to focus on this kind of situation. The last member to ask question is Chan Hock-Fung.
Thank you, Chair. Chair, I have observed that 40% of the illegal workers are non-Chinese. Many of them are holding the reconnaissance, that is Form 8. They are essentially non-refoulement claimants. I hope the administration will pay attention to the situation. They are not just torture claimants, they are illegal workers. We can see from recent figures we have an increasing number of them. So I hope the government can note this. I also want to ask, according to paragraph 8, we have increasing number of cases. So in 2025, we have 10,092 cases. That is a significant increase from before. It's the number of reports basically on suspected employment of illegal workers. How many of the reports end up in successful convictions? Do we have relevant figures? And we have seen the number of employers who are convicted. The sentence, the highest or the average is 19 months. Can you tell us how many cases resulted in a 19-month sentence for employers? We want to make sure we punish illegal workers, but we also need to punish the employers who have employed illegal workers. We need to make sure the sentences are proportionate to really combat illegal workers. Undersecretary for Security, thank you. About number of reports, we do see an increase of this, but it is probably because we have stepped up publicity and we have a hotline now. And what does it mean to have over 10,000 reports? Since September 2025, we have launched a hotline, and from September 2025 to end of March this year, we have received 1,701 calls, and only 377 calls were substantiated reports. We are currently analyzing 27 calls, and 1,052 calls did not have adequate information. I asked what they were about of officers, and they just said they saw illegal workers. They suspected someone to be illegal workers, but they did not even provide basic information such as the time, location, and the relevant individuals. We do deal with each report seriously, and that's why we recorded the number of reports accurately, but preliminarily, only 1/3 or a quarter of the reports can be followed up on. So out of the 10,000 reports, about 3,000 of them we can follow up on. How many were convicted? Well, we have for the figures the maximum penalty. As for the individual cases, we need to review this. How about the question on non-Chinese illegal workers? We have some non-Chinese people entering Hong Kong legally, some of them entering Hong Kong illegally. And we have arrested certain individuals at the premises where we have found illegal workers, and then they submitted non-refoulement claims. And sometimes we have to allow them out to be on reconnaissance, so they became Form 8 holders. We do know that some people are making use of this mechanism to work in Hong Kong illegally. We are trying to tackle the root cause of the issue. We are working with some consulates. We have approximately 14,000 of such claimants still, or relevant individuals still staying in Hong Kong. A lot of them are pending legal proceedings. We are trying to expatriate them as soon as possible. Any other members who would like to speak? If not, I have some questions. In paragraph 4, we have some immigration status of illegal workers. That is the background brief. I understand that 58.7% are the visitors, and we have those who have entered Hong Kong illegally, about 9% of them. But I also know there are some imported workers who are subject to specific employment conditions. Before it's just 0.5 and 0.6%, but in 2025 it has gone up to 5.5%. In 2026, as of February, we already have 11.7%. What does this category of workers mean? Basically, they are imported workers, but they have breach conditions. They have worked somewhere else, or they have worked at some other jobs. All right, so they have come to Hong Kong illegally, but they are not working in the specific locations. Let me give you an example. For example, the worker is imported to be a junior cook for a company, but then the individual ends up working as a waiter. Or when the employer imports workers, they have imported worker to work at 3 shops, but then the workers started working at a 4th shop. Then that would have been a breach of the condition of stay. Right, so I can see the figure increasing from 0.5% to 5.5% or even 11%. So with company applicants, I'm not sure if this is done on purpose or not. I think we need to enhance public education for the employers importing workers. They need to understand if the workers have to work at other locations, it would have been a breach of the laws. We need to step up publicity on this. Undersecretary for Security, let me first clarify, the increase in the figures may be due to us importing more workers. We already made clear with the workers, when they are obtaining relevant identity documents, the specific employment conditions, and they cannot breach the employment conditions. I'll also let Mr. Ho Kai-ming supplement my reply. Thank you, Chair. We have held many briefings for employers. They understand that imported workers must work at specific locations and do designated work. Whether it is done on purpose or not, if they have allowed imported workers to work at other locations or do some other work, it would have constituted a breach. But we do understand it can be inflexible, so we will look at this in the review for labor importation arrangements. However, in the meantime, we urge employers to make clear where imported workers can work and what they can do. We want to offer some flexibility, but that flexibility is not subject to any conditions. So we will step up publicity as much as we can for employers. All right, let's step up publicity. If there are no other members asking questions, we would like to thank the relevant officials for attending the meeting. Moving on to the next agenda item, any other business? There's no other business. Thank you for attending the meeting. Meeting adjourned.